Appreciate it. And members, we are going to hear the bells for a vote. We're advised in very short order. Our next witness is here. The vote is scheduled for 5:30. So I'd like to get your, Mr. Chipeur has traveled from Calgary to be heard today and to give testimony. And so I'm suggesting that we will adjourn now and go to the chamber, cast our ballot, and then quickly return to these deliberations quickly as we can. Are we in agreement with that? I'm not sure if that interferes with Mr. Chipeur's flights or anything, but I think we have an obligation to show up for the vote. So we are going to adjourn.
Suspend.
Suspend. Next witness, who's been very patient and waiting for members to return from voting, who's appearing here today as an individual, direct from Calgary, I understand. Gerald Chipeur, who's a lawyer with Miller Thomson. Welcome, sir. And do you have an opening statement you'd like to make?
I do. Thank you very much, sir.
Please.
Honorable Senators, thank you for the opportunity to share my legal opinions with you today. My views are based on over 35 years of direct participation in the electoral system, and that goes back to 1979 when I participated as a scrutineer on Election Day. I have engaged in just about every aspect of the electoral system except that of candidate. I've also litigated election issues at every level of our courts, including multiple day judicial recounts and Supreme Court of Canada appeals. I've won some and I've lost some, but that is the nature of the electoral system that we have. There are always winners and losers. The winners and the losers rarely agree on anything during a campaign or even afterwards. However, there are three things all participants always agree upon in my experience. First, fairness. Second, integrity. And thirdly, transparency. I've represented political parties from across the spectrum, the ideological spectrum, including the Reform Party, a populist party with libertarian leanings, the National Party, a nationalist party with left-wing leanings, the Conservative Party, a right-of-center party, and the Natural Law Party, a party associated with religious thought and philosophy arising out of Asia, and others. In every case, my clients have desired three primary objectives from the election laws of Canada. First, the transmission of their message to every potential voter. Second, a fair and equal opportunity to participate and to get out their vote. And thirdly, an effective prohibition on the participation in the vote of those not qualified to vote. The absence of any of these three factors would have destroyed the confidence of my clients in the electoral system and would have impacted their faith in democracy. The consent of the governed is crucial to a democratic form of government. Therefore, it is critical that Parliament maintain the confidence of the public in the fairness and the credibility of the vote. In some submissions that I have heard, there has been concern raised about changes that have been proposed in Bill C-23 to the Canada Elections Act. For the record, I support the changes found in Bill C-23 for the reasons that I will get to shortly. My only real criticism this time is the act is getting very long. It's going to rival the Income Tax Act if we don't take care. I would now like to take the committee through three important Supreme Court of Canada decisions relevant to Bill C-23. The first is Figaro and Canada, a 2003 decision of the Supreme Court. This case saw the 50-candidate minimum requirement for registered political parties fall in the face of Section 3 of the Charter. The main points made by Justice Iacobucci relevant to Bill C-23 are found at paragraphs 51 and 72. Let me just very quickly take you to those paragraphs and highlight them for you. In paragraph 51, Justice Iacobucci said, Section 3 imposes on Parliament an obligation not to interfere with the right of each citizen to participate in a fair election. As the Court observed in Lidman, electoral fairness is a fundamental value of democracy. The principle of electoral fairness flows directly from a principle entrenched in the Constitution, and that is the political equality of citizens. Paragraph 72 says this: the Court already has determined that preserving the integrity of the electoral process is a pressing and substantial concern in a free and democratic state. Figaro supports all of the initiatives in Bill C-23 to protect the integrity of the electoral system. And I note that the recent decision by the British Columbia Court of Appeal in Henry follows Figaro and also supports Bill C-23. The second case of note is the Harper and Canada decision of the Supreme Court of Canada in 2004. That appeal upheld limits on third-party advertising. Justice Bastarac in that decision continued the theme of Justice Iacobucci and identified the purpose of the Canada Elections Act at paragraphs 63, 72, and 79. And let me just take you to the first of those paragraphs. The advancement of equality and fairness in elections ultimately encourages public confidence in the electoral system. Justice Bastarac also addressed the question of how much evidence of unfairness in elections must be available to Parliament before Parliament is justified in acting through legislation to address the unfairness. His answer starts at paragraph 77. He said the legislature is not required to provide scientific proof based on concrete evidence of the problem it seeks to address in every case. Where the court is faced with inconclusive or competing social science evidence relating the harm to the legislature's measures, the court may rely on a reasoned apprehension of harm. And then in paragraph 78, he quoted Justice McLaughlin, as she then was, and said, the discharge of the civil standard does not require scientific demonstration. The balance of probabilities may be established by the application of common sense to what is known, even though what is known may be deficient from a scientific point of view. Just for the record, I will refer you to other paragraphs, but I won't repeat them because they basically say the same thing, and that's paragraphs 87, 98, 101 to 104, 111, and then 121. But let me just take you to the quote at paragraph 121. In this case, in that paragraph, the court explained the decision of the Supreme Court of Canada in Libman and concluded that the system, the quote is, nor would it be much better served by a system that undermined the confidence of citizens in the referendum process. My point there is that confidence in the electoral system is a primary focus of the Supreme Court of Canada in its decisions involving the Canada Elections Act. Let me turn now to identification. One of the most significant questions you must ask yourself as senators is whether vouching is part of the Canada Elections Act that promotes fairness and confidence in the electoral system. Or does vouching encourage transparency and accountability? Does it lend credibility to the outcome of an election? In my view, the answer to all three of these questions is no. The next question is whether the vouching model has been replaced with a constitutionally defensible alternative. In my opinion, the answer is yes. That is also the opinion of the Supreme Court of Canada. Let me explain by reference to the Supreme Court of Canada decision in Alberta and Hatarian Brethren. It's a 2009 decision of the Supreme Court of Canada. In that appeal, the Supreme Court of Canada upheld an Alberta government requirement of photo identification to drive an automobile in Alberta. When you think about it, photo ID is required to attend many schools, to travel by commercial air, to sign many legal documents, to visit a bar, and significantly, to get into this building to testify before you today, one needed a photo ID. It seems to me that it would make no sense to impose a different standard for an act of citizenship, and that is of voting, which is much more important and of much greater consequence. Chief Justice McLaughlin highlighted the legitimate interest of the government in preserving the integrity of public systems and in preventing fraud. And again, I won't read those, read her comments, but they can be found at paragraph 64, 80, 81, 85, 101, 102, and 104 of the decision. And I note that, again, the British Columbia Court of Appeal decision in Henry would support that view of the decision or that part of Bill C-23 that removes vouching from the Canada Elections Act. Thank you very much for this opportunity to make an opening statement.
Thank you, Mr. Chipeur. I'm sure we have questions for you.